Hi, Tim Blankenship here with Divorce661.com, and today I'm doing a review of a case. I'll tell you, half the time when people call us, they will have tried to do their divorce case on their own and get their judgment rejected for a variety of reasons. A lot of times the courts, when they see if your paperwork is quite a mess, they'll only reject it for one or two reasons, send it back to you, you'll fix it, send it back in, and they'll reject it again for other reasons. And the reason is because they're only looking for a few issues. So when people call me and they say, Tim, like in this case, they said, there's only one or two fixes, and we could probably take care of it, but we just, we don't want to have it get rejected again. I said, okay, well, what I do then is we do a full review from the very beginning, the petition, all the way to judgment. And I want to go over with the findings because it was a far cry different than what the court said. They found two issues, the court did. I found 5. And all these were actually major issues, and even for me, it's going to be a challenge to get it through because we're dealing with certain procedural issues. So you can watch this video. I'm also going to have this as part of the part of my blog, so you can read this as well. So the first issue was I had to end up redoing every single form. I'm just going to read this to you. It'd probably be easier because this is the direct email I sent to the client. I said, and I prefaced by saying, look, it's not your fault. There's a lot that goes into this, and I didn't want her to take the email the wrong way. So I said, first I have to redo every single form. The only form I did not redo was the petition, and that was because it was already amended, and you only get one amendment. Otherwise, I would be amending that form as well. So they had already made an issue on the first petition, and then they amended the petition, and that was wrong, and it was wrong for a couple reasons. The names, first of all, the names that they used on the original petition was first, middle, last, and on the amended petition was first and last. Here's the other issue. Second, when the amended petition was filed, it was filed by itself. When you amend the petition, you also have to file an amended summons and an amended UCC-JEA, which is the FL 105, even if there are no changes to them. Again, you would not know this. I was trying to explain, you would not know this. So if you amend your petition, you get one chance to amend your petition, and if that's wrong, you cannot have a third amended petition unless you file a motion with the court requesting permission to do so. So it becomes a complete pain in the butt, because to get a hearing is going to take you at least 2 months. So just to recap, when you file your amended petition, you have to file an amended UCC-JEA, if there's kids, and an amended summons. All right, so last amended petition, okay. So I'm going to file the FL 105. So what I'm going to do is I'm going to try, even though they filed because they already filed the second amended petition, I'm going to try and send it down to court with the amended summons and amended UCC-JEA and see if they'll file those and just say, hey, these were missing from the filing. Otherwise, they may say, no, we're not going to accept that, and you need to file a third amended, but first you have to file a hearing. So we're going to try and slip this through, and that's the kind of the challenges I was dealing with. Third, and you really won't like this unless you're in a hurry to finish the divorce, because an amended petition was filed if it would have to be re-served. They had already filed the initial petition, served it, filed the amended petition and served it, but that service doesn't count because they didn't file all the other amended documents with it. So I said, I hope you're not in a hurry to finish the divorce because an amended petition was filed. It would have had to be reserved because the FL 105, the UCC-JEA, and summons were not filed with it. Even if it was served, it would be bad service. None of these things, by the way, were issues with the court that they located because they just didn't get that far through. So I say, so if the court allows us to file the 105 and the summons, service cannot occur until those are filed, therefore we'll be starting over from the very beginning. And I had to do literally every form over again because everything else was pretty much wrong. I go on to say, as you can see, there's much more to fix than what the reject said. This is very common. Even with the way I'm trying to do this, it may not work. The correct way would be to file a motion with the court, get a court date in 2 months soonest, get an approval for the second amended petition, or third amended petition rather, and file that, get it served, and then 30 days later, file the judgment. In the interest of time, I want to spare those 2 months, and once the FL 105 and summons are filed, I can have you sign a notice of acknowledgement of receipt of the petition, wait 30 days, and turn in your judgment. Again, only then will we know if they will accept the later filed 105 and summons. So you can see how challenging it can be. We've been doing this for 5 years. We've handled thousands of cases. Every court is different. Every judge is different. Every department is different. Every clerk is different. So some allow certain things, some don't. We'll have to see once we get through this process if they'll accept the judgment based on service with documents filed out of order and not filed together. So that's Tim Blankenship, Divorce661.com. Call us if you need assistance with your divorce. We handle all of California. You can reach me at 661-281-0266 or go to Divorce661.com for more information.